The equivalent paragraphs, I won't read them, are para 178 and 208 in Justice Ramana's judgment.
178 and 208.
178 and 208. The third principle, and this note I want to place, because this is the prima facie test. We have heard a lot about Section 8 is only a prima facie approach. What is a prima facie approach? How does a court apply it? Para 147.11, page 194, tells us how to do that. The second sentence, the court as the judicial forum of the first instance can exercise prima facie test jurisdiction to screen and knock down ex facie meritless, frivolous and dishonest litigation. Limited jurisdiction of the courts ensures expeditious, alacritous and efficient disposal when required at the referral stage. So something which is ex facie meritless or frivolous, ex facie there is no arbitration agreement. That is something alone that a court will see under 11.6a. The rest, if there's even a dispute or a doubt, will be sent to the tribunal. When in doubt, refer, is what this judgment itself says. And a similar principle, I'll just mention the para number. At para 154.4, at page 196.
That's what we have said, even in the case of limitation. If you get a case under 11 where somebody's come after 10 years, 20 years, or something doesn't turn really on a very detailed interpretation.
On a demurrer.
Justice, I think, Justice Natsima and Justice Pardiola were sitting with me when we found a case like that. And then the whole object of sending parties to arbitration again it defeats the purpose of arbitration.
So, without much inquiry, without determining some heated controversy between the two parties, if a court can ex facie see it, of course, that is a safeguard under 11.6a. No one is disputing that. But stamp will never be such a question, particularly because, as we have seen, it's a curable defect.
That's the whole thing. This Stamp Act, anything to do with stamp. If it has a possibility of being curable,
yes.
Let us say even recognize the possibility of being curable, then how do you throw it out at a threshold?
I bow to that. My lord is absolutely correct.
So, in any scenario, possibly, Stamp Act requirement in any formulation of it, any variation of it, I'm very doubtful that at all it can be looked into.
My lord is right. I'm going to place a judgment of your lordships on that immediately after I complete this, showing that it doesn't, irregularity in stamp or even non-stamping doesn't render a document invalid. Your lordships have held that. I'll place that. But very quickly, I'll just give the paras on this. I won't trouble my lord. But the equivalent para is para 232, Justice Ramana's decision, where he expressly refers to Section 8. That is at page 234. And he says in para 233 at page 235 that the defendant has to establish prima facie case of non-existence. It's the other way around. The defendant will show that ex facie there is no arbitration agreement. Well, the fourth proposition, again, in the interest of time, I'll just give the paras. Paras 236 to 238 at pages 235, 236, relying on your lordship's Mayavati decision. Ultimately says it's only contractual validity of the arbitration agreement that has to be seen under 11. In other words, Section 7, is it complied with? On the face of it, ex facie. If there's, again, even on that, if there's a dispute to be gone into, it will go to the tribunal. But if ex facie or lordship is fine, there's just no agreement, of course. And para 244.5 and para 146. They all go on the basis of this kind of validity. And my lord, I adopt Mr. Datar's submissions. I'm not going to repeat them. Under the Contract Act, what is not a valid contract or what is a void contract is only one which is voided under Section 23 or under Section 10. Nothing more than that. Stamp Act doesn't come into into that at all, not even into the contract.
We have elaborately at this moment.
Yeah, so I'm not touching that. I adopt that, my lord. And the fifth, my lord, set of paras in this judgment, I'll just give the para numbers. Paras 151 to 152, page 195, and para 220 at page 230 is again the principles of a broad pro-arbitration interpretation and a one-stop forum for adjudication.
What is the latter para?
Para 151, 152
195.
at page 195 and para 220 at page 230. They speak of a one-stop adjudication presumption. You start from the presumption that everything goes to the tribunal. Now, applying this to 11.6a, it's not that because the word existence is used, everything coming under that umbrella of existence has to be gone into. The legislature has said confined to the existence, and given the principles under section 5 and these very salutary principles of law, a court would restrict by way of an implied negative competence, even under 11.6a, to an ex facie examination. Now, my lord, this is more so because of the next point, which has been argued. I'll just point out what I think is relevant and which has not been shown to your lordships. Under the Stamp Act, 1, non-stamping or understamping does not result in an invalidity or voidness. And 2, it is a curable defect. Now, if my lords kindly turn to my written submissions, volume 1B at page 15. I won't read all of them.
It's also waivable. You can waive it because.
And one can waive it. My lord is right. In fact, there are 3-4 sections which I want to just point out. Again, I won't read them. They've been read. Barring one, they've been read to my lord.
Waiver is also by conduct. It's far more liberal. It doesn't have.
My lord is absolutely correct. And if that is so, then under 11.6a, how will a court go into that? I'm obliged. I'm obliged. May I, my lord, adopt that as my submission? I think that's very well put. In fact, Mr. Banerjee also argued, an 11 court is not even a 2-1e court. Whether it can take evidence is also a question. But therefore, it's impossible to go into these disputed questions under 11.6a, despite the use of the word existence. That has to be read purposively as meaning only ex facie if there's non-existence. There's a probability of existence, it must go to the tribunal. Now, curable defect and invalidity. The first point, section 35 is very clear. It visits a non-stamped or not duly stamped instrument with only 2 consequences. One is it is inadmissible in evidence. And the second is it shall not be acted upon. And my learned friends have emphasized the second, not be acted upon. And they have tried to elevate those words to unenforceability leading to voidness and invalidity. I'll presently show why that can never be so. The curable, where the defect can be cured is section 36 we have seen, where once an instrument is already admitted in evidence, no stamp objection can be taken to its admissibility later. Section 37 and sections 42, which I don't believe have been shown. 42 I don't think has been shown to my lords. But 42 only allows the collector on payment of duty and penalty to stamp the document, and after stamping, then it can be admitted in evidence, and the shadow, as it were, of section 35 is lifted. In NN Global 2, and Mr. Datar has pointed this out, there's a slight contradiction because in para 108, it is said this invalidity is not in the sense of being stillborn, but in para 103 it says it's bereft of life. We leave that aside because, in fact, your lordships have held very clearly that no invalidity results. I'll come to that just a little later. I will make 2 points before I come to that. My lords have seen Hindustan Steel. The judgment in Hindustan Steel. And my lord, I've set this all out in my written submissions, pages, paras 32 to 47. So I'm not going to read it all. I'm running through this because much of this has been argued. I've set out with extracts from the judgments as well. Paras 32 to 47, starting at page 15. But I want to make one point. Hindustan Steel we have seen, and it is directly on point about curability. But there's another aspect your lordships may take into account. There's a judgment of your lordships in a totally different context under FEMA, in the Vijay Karya case, which my lords will find in volume 5A, page 1545. I'm not even asking my lords to go to that. But the principle in Vijay Karya's case is this. I've referred to it at para 37 of my written submissions. And the judgment is found at volume 5A, page 1545. Citation is 2020 11 SEC, page 1. The relevant
Page number?
The page number is 1545, volume 5A. And at 1632 is para 88, where your lordships have laid down a principle as to what happens when something is capable of regularization or post facto permission in the context of FEMA. This is that whole series of foreign awards coming. It's a general problem.
A very small niche point, which is that looking to the nature of stamp act.
Correct.
Are we required to look into stamp act at all under 11.6? So it should be left. This is all.
Yes.
Why should we go here and there on the issue?
Only to assist that conclusion that if it's a regularizable, curable defect, then your lordships, even in the context of other statutes such as FEMA, which also have a public policy connotation, have said the transaction is not voided. That's what para 88 says. The transaction is not voided because it's regularized. That's the only principle I want to cull out from Vijay Karya, but I'm not taking my note. I've set out, my lord, I'll just give my lords the reference in my submissions to the Singapore position on stamp expressly, my lord. My lord sees paragraph 80 of my submissions. Para 85 onwards, my lord, page 33. They have similar provisions. It's not that they don't. My lord sees para 86. (51)(1) of the Singapore Stamp Duties Act corresponds to our section 33, the impounding section. And section 52 in the next para corresponds to section 35. Same language. Not admissible in evidence, must not be acted upon. Identical language. And in para 88, I've referred to one decision of the Singapore courts, where it is categorically held that this is only a rule of evidence and does not affect the validity of an unstamped document. That is in this Muhammad Amin bin Muhammad type case. The case, I'll just state for the transcript, is found in volume 5B, page 4678. Even in NN Global, Justice Ravi Kumar at para 182 accepts that stamp duty defects are curable. I mean, one other internal piece of evidence to show why the words shall not be acted upon can never be equated with voidness or invalidity. If those words were equated with voidness or invalidity, then there's no question of curing a void act. My lords put it to me. So the fact that you have provisions like 36, 37, 42 itself means shall not be acted upon in 35 can never be extended to an infirmity of invalidity or voidness. That's not what Parliament intended. Now, if my lords kindly go on, it will be very quick with this. My lord, page 19 of these submissions of mine, I've set out reference to a judgment of your lordships on this. Para 44 of my submissions. In Thiruvenkandam Pillai's case, Justice Ravindran's decision, 2008 for SCC 530, and I'll just read para 13, which I've extracted. It's in volume 5A at page 702. But I'll just read para 13 from here. The Stamp Act is a fiscal enactment intended to secure revenue for the state. In the absence of any rule requiring consecutively numbered stamp papers purchased on the same day being used for an instrument which is not intended to be registered, a document cannot be termed as invalid merely because it is written on two stamp papers purchased by the same person on different dates. Then the next sentence, even assuming that use of such stamp papers is an irregularity, the court can only deem the document to be not properly stamped, but cannot only on that ground hold the document to be invalid. Even if an agreement is not executed on record stamp paper, it is admissible in evidence on payment of duty and penalty under section 35 or 37. If an agreement executed so, and the last sentence, but admissibility of a document into evidence and proof of genuineness of such document are different issues. Your lordships have held this under the Stamp Act. And para 45, I've set out the instructive judgment of the Calcutta High Court, which Mr. Banerjee also referred to, and Gulzar. And the next para 46, a number of other courts, Bombay, Andhra Pradesh, Calcutta, have held this. It doesn't need to voidness or invalidity. So this is too well settled a proposition. I mean, Lord, just 2 points and I'll be done. Lord. One is, we have viewed this matter from the perspective of section 11(6), court appointment of arbitrators. But there is in existence a huge body of appointment of arbitrators by individuals. There's no dispute to start with. There's also increasingly growing in appointment by arbitral institutions. In fact, the policy of the law is to encourage the interposition of arbitral institutions. There's a proposed amendment which is not yet notified.
All those cases that will go before the arbitrator.
Correct. So I have also said,
Government can be in 11(6), why take a different view than what would happen in?
That's right. And I'm obliged. The point I'm making here is your lordship's view on 11(6)(a) must try to harmonize even appointments by institutions.
With how arbitration in other areas, in other methodologies take place.
So, for example, all arbitration institutions have these rules. SIAC, for whom I appear, has rules 28.1 and 28.2, which essentially an objection as to jurisdiction, as to the existence of an agreement can be initially raised before the full court. The court has the jurisdiction at that stage to knock out a claim if it is prima facie satisfied. Again, the prima facie test. Otherwise, it sends it to the tribunal for a fuller decision. And I may only ask my lords to mark 5 or 6 paragraphs of Justice Roy's decision in NN Global. That is paras 368 to 376, where he surveys the rules of several leading arbitral institutions. All of them have a prima facie test at the first instance. Para 368 at page 462 of volume 5A, up to para 376 at page 466. And he also refers to the Justice Sri Krishna report, which recommended encouragement of institutional arbitration. Because if my lords don't hold the prima facie test in 11.6a, then individuals and institutions will be left in a quandary. What do? Because the observations in NN Global, albeit in the context of Section 11, will apply to them as well. If it is held that an unstamped agreement is void, what do? Now, one further problem. Neither individuals nor arbitral institutions are empowered to receive evidence. So they would not be covered by the bar under Section 35 of the Stamp Act, because that only applies to persons who are authorized to receive evidence either by consent or by law. Or indeed, they would not have the power of impounding under Section 33. So they can't impound. There is no bar under 35, but there's your lordship's decision in NN Global saying void and non-existent. So they are in a complete quandary as to what to do. Therefore, it is important your lordships decide this matter holistically, because otherwise a very important segment gets left apart. And there, I must say, my learned friends, I've had a cursory look at their submission. Mr. Shyam Diwan, I'll just note it for the transcript, in para 4.7 of his submissions, accepts that arbitral institutions have no power to impound, but they might be able to appoint a tribunal, because Section 35 is not applicable to them. And Mr. Nakul Diwan, at para 23, also says arbitral institutions have no power to receive evidence. Equally, Mr. Shyam Diwan, at para 4.7, agrees that an arbitral tribunal has the right to impound a document under Section 33, because it is authorized to receive evidence by consent of the parties. Not by law, but by consent of the parties. And therefore, it can impound under 33, which is my submission as well. And one more reason why it should go to a tribunal. And Mr. Nakul Diwan in paras 24 and 25 finally comes around to the same view that even under 11, your lordship should be pleased to refer it to the tribunal. Mr. Shyam Diwan raises the point that it may not be convenient for an arbitral tribunal to do this. It doesn't have the infrastructure to impound, send the document to the stamp authorities. But that's an issue of convenience. It's not an issue of law or jurisdiction. But I'll leave it to my learned friends to satisfy my lords why it should not be sent to the tribunal. Now, one point, and then I'll draw my conclusions very briefly. I'll just give the pages because it doesn't arise before my lord, but it puts the matter in perspective. Paras 48 to 58 of my written submissions, pages 21 to 24, deal with this whole issue of who is entitled to impose stamp. Does it come under list 1 and therefore under the Indian Stamp Act?
You need not go
That's
into that. Actually.
They're not required to
They're
point
not.
out.
But
You saw those entries,
that's
why
right.
you don't have to go into.
I only wanted to say one thing and I'll be done with this. Under the state stamp acts, the residuary articles have stamp duty of 50 rupees and 100 rupees. Now, the process of arbitration ultimately cannot be held up for 50 and 100 rupees, which can easily be cured, because all the residuary articles are low figures. NN Global, I'm not going to analyze again. My learned friends have analyzed it. I don't know, just my conclusions. First is that your lordships should be pleased to adopt a purposive interpretation to uphold the intent to arbitrate. In deference to party autonomy. And I've given some cases where your lordships have done that under the Arbitration Act in Nandan Biometrics, etc. I've mentioned them in my written statement. The second is Section 5 of the Arbitration Act must be given full effect. It's a very wide non-obstante. And the Arbitration Act is a complete code. Your lordships in the Amazon case, I'll again just give the para number, para 43, and the judgment is found in volume 5B at page 623, have held that the new Arbitration Act with the amendments is a complete breakthrough from the old position. Therefore, every provision of that act must be interpreted given the overarching principle of Section 5 and the principle of an implied negative covenants competence. The third, as held in Vidya Drolian, that so long as an arbitration agreement satisfies the requirements of the Arbitration Act, ex facie, by adopting the prima facie test, there's no question of a court holding up the arbitral process by entering into an examination of whether duty is paid, whether it's understamped, under which article it falls, etc., etc. The fourth, since a tribunal is authorized to receive evidence, Section 33 of the Stamp Act will apply to it squarely. It can impound the document and start the process of stamp collection. There's no reason why a court, courts are already clogged with so many matters, why they should be clogged up into this. Fifth, such an interpretation of 11(6)(a) will also harmonize the process between appointments by courts, by individuals, and by arbitral institutions. An arbitral institution certainly will take just a prima facie look before the tribunal is appointed. An individual may not do that. The one who wants to refer to arbitration will refer, the other one will go to Section 11. So it's unlikely, but sometimes individuals do, because very often these objections are raised halfway through an arbitration. So it's not unheard of. Then, my lord, 6, the trend is towards encouraging institutional arbitration. The Amazon case has said so, and your lordships are familiar with the Sri Krishna report, which has said so. And therefore, to leave institutions in a quandary and to effectively block the process of institutional appointment by saying go into stamp objections will not subserve this broader public policy objective. And lastly, there is also a trend towards investing arbitral tribunals, a parliamentary trend, towards investing arbitral tribunals with powers of a court. This is the legislative prescription of Parliament. I'll give a few examples. The amendment adding 17(2), which prevents a Section 9 court, which effectively prevents a Section 9 court from giving interim relief, because under 17(2), the orders of an arbitral tribunal are given the force of law of orders of the court. And corresponding provision is 9(3). Section 11(6)(a) itself. Section 8 was amended in 2015 to include prima facie, to bring it into line with 45, where under Shinitsu, your lordship said, well, only a prima facie look to foreign arbitration. And even 12. Under Section 12, even impartiality and independence, the first objections must go to the tribunal itself. So the whole trend is empower the tribunals more and more in deference to the principle of competence. And this, in my respectful submission, will subserve the scheme and object of the Act: minimum interference of courts, party autonomy, and one-stop adjudication. And ultimately, in a lighter vein, this might encourage the stream of trade and commerce, and ultimately more stamp duty might result as a result of this, rather than holding it all up for stamp objections to be decided by courts. I'm deeply grateful for the time I've been given.
Who are you appearing for now?
My lords have been grateful when I was appearing in the Constitution bench for inviting submissions. So 5 to 7 minutes, my lord.
Can we suggest one thing?
Yes.
We have to wrap up the proceedings today.
Yes.
It may not be in the interest of anybody that, we leave it on.
I understand.
So what we'll do is, we'll look at the submissions of all the interveners.
Yes.
Would have much liked to hear you all. You've put in a lot of industry. Please rest assured we'll read all the submissions of the interveners. If we have something at the end in response to what Mr. Diwan has argued, and since we have heard Mr. Datar, Mr. Gaurav Banerjee, and Mr. Daras Kambata on this side, in rejoinder, if we have some queries, we'll put them to the intervener. I think that may be better.
2 minutes for one aspect.
So we can't give 2 minutes to everybody. Thank you. Yes, Mr. Diwan. We'll try.
Respectful submission.
Do this. Give us your submissions. Yes, Mr. Diwan.